All right, so the rights of the accused. The bedrock principle of how our U.S. courts protect, or why our U.S. courts protect the accused people so much, the people who are accused of being criminal, is that our courts believe that it is better to let 10 people who are guilty go free than to have one innocent person be punished for something they didn't do. And so that's why we have that concept that you are innocent until you are proven beyond a reasonable doubt that you are guilty. There are several things that help in this process. The first is habeas corpus, and habeas corpus is a writ of habeas corpus prevents unjust arrests and imprisonments. Prisoners need to be brought before court and show good reason why they should not be released. You can't just throw somebody in jail because you don't like how they look. So you have to show that they're a danger to society, or that they're going to be a danger to themselves, or something along that line. It also deals with bills of attainder, and a bill of attainder is a legislative act that inflicts punishment without a court trial. So a good example of a bill of attainder would be like a speeding ticket, because you just pay it. It's an automatic payment if you don't challenge it. Littering laws would be another thing. It's just a fine. You pay it without challenging it, and you don't have to go through a court trial unless you challenge the decision. Another thing is ex post facto laws, and ex post facto laws is where you would apply laws to criminals who committed the crime before the law was passed. So a good example would be like for death penalty. Here in Iowa, we don't have the death penalty, and so we have a number of people who are serving life sentences with no parole because they committed murder, but since we don't have the death penalty, we can't kill them. Instead, they're just going to be in prison for the rest of their lives. Now, if next year Iowa decides to become a death penalty state, if we allowed ex post facto laws, all those people who are on death row, or who are serving life imprisonment, would then get automatically converted to death row. And the U.S. court decided that's not right, because for some people that's a deterrent. That's saying, I don't want to commit this crime because I could be put to death myself. But if in Iowa we didn't have that, then they were okay with killing people because they're just going to have a life sentence. But if it had been the death penalty they were facing, maybe they would have rethought their actions. And so you can't punish them for something that wasn't a crime at the time that it was committed. Okay? So, a grand jury is another way that we help out the accused. And a grand jury is only for those who are accused of serious crimes like murder or kidnapping. And a grand jury is made up of voters who basically what they're doing is they're returning an indictment. An indictment is a formal complaint that's charging the accused with the crime, saying there's enough evidence that we think you need to go to trial, and so we're accusing you of murder, or we're accusing you of kidnapping, whatever. But a grand jury is never the trial jury. That's a totally different thing. The grand jury is usually held in a secret session. Usually only the prosecution is present. So you only hear really one side of the story. But and so that's kind of one of the things that people have against it. There's a lot of critics of the grand jury saying that it's kind of time consuming. It's one more step. Why do we have to have this one more step? Because of that, it's also kind of expensive. And the jury only listens to the prosecution anyway, so if they don't have a chance to hear the defense, are they really making a valuable decision? The next thing is double jeopardy, and double jeopardy comes from the Fifth Amendment. And this basically says that you cannot be convicted of the same crime twice. So you can be put on trial for things multiple times, but you can't be convicted. They can't come up with a verdict. So like if you commit a crime like you are selling drugs, well, that is a violation of both a federal law and a state law. So you could have a federal trial and you could have a state trial. But if you are convicted at the federal level but not at the state level, they can't try you again at the federal level. They can try you again at the state level because there's no conviction there. But if there's no verdict, there's no jeopardy, and so you can be tried again and again. Now, you can have several crimes in one act. Like if you break into somebody's house, you have illegal entry. If you stole something while you were there, you have theft. If you punched a guy's lights out, you also have assault. So you have multiple crimes within one act. But if there is no verdict, you can be tried again. So it all comes down to verdict. It does not apply to the appeals. Appeals is a whole different animal. This is turning into a really long video. I apologize. Let me see where I need to stop at here. Okay, so not that much left, I guess. Okay, so we have the speedy trial, and the speedy trial is a reasonable time without undue delay, that you are getting to your trial as fast as possible, and each case is looked at on its own merits. The Speedy Trial Act of 1974 says that sets the standard that from the time of your arrest to the beginning of your trial should be no more than 100 days. Now, there are exceptions for things like if you need to have mentality tests, or if a key witness or the defendant is sick, that may affect it. A public trial is part of it as well, and that's within reason. A judge can limit the number and kinds of spectators at a trial. A lot of it depends on, okay, is there going to be disruptions because of the people that you allow in? Is there embarrassing testimony? If it's like a rape case or a child pornography case, that's kind of embarrassing things for the victim to talk about, and they probably don't want to be open with a bunch of strangers about it, and so the judge may limit who can come in and see the case at that point. The media involvement, they get the same rights as the people, but if there's too much publicity, that can affect the accused, and so you don't want to have too much publicity beforehand because that might skew the jury. Speaking of jury, we have trial by jury. You're supposed to have an impartial jury, and an impartial jury is one who has not made up their mind about the crime or the criminal. You can waive your right to a jury, so if you're supposed to have a jury trial, you could say, nah, I would just want to have the judge. I would just want a bench trial, and that's where only the judge decides if you're guilty or not. If you decide to have a jury, there are two different kinds of juries. You have a criminal case jury, which is made up of 12 members, and they must vote unanimously. They have to all say guilty, or they all have to say not guilty. Otherwise, they turn out to be a hung jury, which means that you can be tried again because there's no conviction. The second type of jury is a civil case jury, and on civil case juries, you can have as few as 6, so it's not a set number per se, and they do not have to have unanimous decisions. Now, no one can be kept off of a jury. You have a right to be on a jury, but you can be taken off of the jury list if you show that you're not impartial, that you have already made up your mind that I want to be on this jury so I can fry this sucker kind of idea. So if that's your mentality, you're not going to be on the jury. And finally, we're going And finally, we're going to talk about self-incrimination. And self-incrimination is where you are openly saying, yes, I did this crime. For people who are criminals, who are accused of the crime, the burden of proof to prove that they did the crime is on the prosecution. You can only claim self-incrimination for yourself. You can't claim it for family. You can't claim it for your spouse. And it does not protect you from things like fingerprinting or photo lineups or handwriting samples or blood tests, any of that stuff. But you also cannot be forced to confess. So you can't be withheld from going to the bathroom or getting some food or sleep deprivation. That would all be violations of that. In order to help the accused understand more of what their rights are, we have the Miranda rule. And this comes from the case of Miranda versus Arizona. And it deals with Ernesto Miranda. And he had been accused of kidnapping and rape, and he confessed to it, but he was not told his rights by the questioning police officers. And so it goes all the way to the Supreme Court. And what it says is that rulings and convictions are not upheld if a person doesn't know their Miranda rights. That's how we get the idea of Miranda rights. These are constitutional rights that everyone is entitled to. And I know most of you have heard probably on movies or TV shows that you have the right to remain silent. Anything you say can and will be used against you in a court of law. You have the right to an attorney. So if you don't have one, or if you cannot afford one, one will be provided for you by the state. Like I said, you probably have heard of this before. Well, critics of the Miranda rule say that it's an obstacle to law enforcement, that it puts criminals back on the streets, because in the heat of the moment, you might forget to do this. And so that's going to put a criminal back on the street. Supporters say, no, it makes for more effective law enforcement, that these police officers have to independently secure the evidence rather than trying to finagle a confession out of somebody. So it makes sure that you have the proper evidence to prove beyond a reasonable doubt that this person committed the crime. So you can see kind of the argument both ways, I guess. Okay, so we are picking up with the rights of the accused, punishment, looking at how do we punish those who are accused of crimes. Excessive bail and fines is with the 8th Amendment. And bail is the sum of money that the accused can be required to deposit with the court as a guarantee that they're going to appear in court, that they're going to show up for their trial date. Not all suspects are entitled to bail. They're just safe from excessive bail. So there's a distinction there. Most of them come under preventative detention, which means that you can be held without bail in order to prevent further crimes. Maybe you're a serial killer, or maybe you're a serial rapist, or you want to kill a family member, or whatever. So it's something that you repeatedly do, and so in order to prevent it from happening again, we're going to keep you in a jail cell until your trial. Like I said, it also protects you from excessive bail, but it also protects you from excessive punishment. And cruel and unusual punishment is included in the 8th Amendment, looking at unnecessary cruelty. And a lot of this has dealt with capital punishment, and capital punishment is the death penalty. And there's a lot of arguments for and against the death penalty, and what is an acceptable way to execute someone. And it has raised many questions. However, the death penalty is acceptable under the Constitution, although every so often they make rulings about what kind of execution you can do. But basically what the Supreme Court today deals with are different rulings about who can be executed. For example, the Supreme Court has ruled that a person who is insane at the time set for their execution cannot be put to death. They also take into consideration age. And the question then becomes, okay, when are you considered an adult? They also take into consideration the impact that the crime has on the victim's family. Did you take away both parents from their children, or, how did it impact the family? Treason is the only crime that is actually defined in the Constitution. It's not defined through states or through Supreme Court rulings. It's the only one that is actually defined by the Constitution. And treason is basically two things. Number one, you are waging war against the United States, or number two, you are giving aid and comfort to the U.S. enemies. Now, you cannot be convicted of treason unless one of two things happens. Number one, two witnesses to the same act come forward and say they saw you do it. Or number two, that you confess in court that you did it. So it's kind of hard to actually be convicted of treason. And treason can only be committed in wartime. And so that makes it, again, another hard thing to prove and a hard thing to actually get convicted for.